Court of the State of South Dakota, the Honorable Chief Justice David Gilbertson presiding, is now in session.
Please be seated. Good morning and welcome to the third and final day of our October term held here at the University of South Dakota School of Law. The first case for oral argument this morning is Joshua, is it VORTHERMS?
VORTHERMS.
Okay. It was the appellant and the state's the appellee. And for the appellant, we have Ms. Nicole Carper, an attorney from Sioux Falls. And for the state appellee, we have Ms. Bridget Hoffman, an assistant attorney general from Pierre. Ms. Carper, you may proceed, and you have 20 minutes.
May it please the court?
Morning.
As you indicated, my name is Nicole Carper, and I am the attorney for Joshua VORTHERMS, who is the appellant in these proceedings. Judge, the circumstances and facts that bring us here today stem from a serious motor vehicle accident that happened in Minnehaha County at about 2 o'clock in the morning back on July 1st, 2017. This accident took place right at the Brandon Valley exit on I-90. Well, two vehicles were involved. Both were heading west on I-90. Something happened that caused both vehicles to leave the traffic way, roll over, and end up in the ditch. The most, I think, salient person that I'm going to talk with you about today with respect to the first issue that we raised on appeal is Trooper Bowman. And so when I'm speaking about the facts, oftentimes I'm going to be relaying them to the court as Trooper Bowman testified to at the motion to suppress hearing and also at the ultimate trial in these proceedings.
As to the facts, just reviewing the briefs, is there really any dispute as to what happened here?
No, I don't believe there. Well, I mean, no, there's no dispute.
For purposes of your issues on appeal?
I would agree with that. So it's interesting in that sense.
Okay.
All right. So I hope that makes more sense in terms of why I'm not doing a more broad or factual overview, just simply because I think the issues are pretty squarely before you and the facts I think are generally agreed to. As the court is aware, there were two issues that were raised on appeal by Mr. VORTHERMS. First and foremost, whether the warrantless blood draw that was done on Mr. VORTHERMS at the request of the trooper in this case was a violation of his constitutional rights as guaranteed to him by the Fourth Amendment of the United States Constitution and Article 6, Section 11 of the South Dakota Constitution. So the information that this trooper has as he's kind of coming into this set of circumstances, if you will, is a dispatch call that's at about 2:18 in the morning. Accident happened approximately 2 a.m. We don't have exact timings for some of those parts of the case simply because there weren't a lot of witnesses that were involved. There wasn't anyone that came forward and talked about having actually witnessed what happened. We did have an off-duty police officer, a detective, that came onto the scene shortly after, but that testimony is, or that witness's testimony isn't so relevant to what we're talking about here today. So as far as Trooper Bowman is concerned, he's dispatched at 2:18 for a rollover accident. I believe he has information that there's injuries, and he also has information of the location of the accident, which is off the interstate on I-90 by, I think it's mile marker 406. And he's aware that there's a report of a man standing on the side of the interstate that doesn't have a shirt on, is wearing bottoms, maybe has no shoes on, and is trying to flag down traffic. So while Trooper is en route to that location, he receives further information that the individual or a person matching the description of the guy on the side of the road is now at the Holiday Inn Express. And that location is less than a quarter mile away from where the actual accident site is. So rather than going to the accident site, Trooper goes to the Holiday Inn Express, where he comes into contact with Joshua VORTHERMS. Joshua is shirtless. He has pants on, one shoe, blood all down the front of him, holding his shirt up to his head to staunch the bleeding of a pretty good head cut. And that's the condition that Trooper Bowman finds him in. I think his immediate observations are that it couldn't just be a coincidence that we have two individuals with no shirt and shoes who appear to have just been involved in a car accident. So he's pretty sure that this individual is the same individual that was on the side of the road that was reported earlier. He also notes an immediate impression of the odor of intoxicants upon talking to Joshua. And very quickly after asking him, have you had anything to drink, gets information from Joshua that indicates, yeah, I've had a couple. So the other, I think, important thing for us to
Ms. Carper, let me stop you just a minute. So
Sure.
we're looking at it with the benefit of hindsight here today.
Right.
So we look back on what happened, and the officer arrived at, I think, about 2:30.
Correct.
He's there for 20, 30 minutes, and then the ambulance comes and takes the defendant.
Mm-hmm.
So in that 20 or 30 minutes, when do you think that Trooper Bauman should have requested a search warrant?
Well, I would say, certainly at the point that he becomes aware that this individual is the same individual he thinks that was on the side of the road. The dash cam footage suggests that they knew that he was most likely involved in that accident because he had glass embedded on the left side of his head, suggesting that there was an impact there. He admits that he was involved in some accident. He's kind of vague about that because I think his head injury and a number of other factors, and certainly the warrant should have been requested at the point that the sheriff's deputy is able to obtain the PBT just shortly before Joshua was put into the ambulance.
That's about the time they're putting him in, as I understand.
Sure, right.
Right. So you're saying at that point?
Well, I think it's arguable that the warrant could have been applied for even before that point based on the information that law enforcement had. It's not a burden of proof beyond a reasonable doubt to obtain a warrant in a case like this. He had reason to believe the client was involved in an accident, reason to believe that Joshua was drinking by Joshua's own admissions and the officer's own observations of smell. And so at that point, I think he would have had sufficient information to ask for a warrant.
Did he even know the person's name at that point?
Well, that's unclear. I think when we look at the records from when he was checked into the hospital, he's still under a Jane Doe, or Joe Doe, I should say. But at that point, it's unclear whether the trooper actually knew what his name was. But there's, in my view, no doubt that all three of the law enforcement officers that were at the Holiday Inn Express site believed that Joshua was involved in that accident, that Joshua was a driver, and that Joshua was under the influence of alcohol. And so given that, at a minimum, I would say, Your Honor, in response to your question, that warrant application process should have begun at the point that they get that PBT result that backs up the other observations that they've already made.
Wasn't it unclear at that point whether or not he was the driver? And in fact, weren't they focused on trying to find the actual driver? They believed there was another person in the pickup that they were looking for.
Well, I would submit to you that that's possible that focus might have been more a focus for the individuals that were actually on scene. There was only the one report of the one individual standing on the side of the road trying to flag down people. That individual then matches the description of the person found at the Holiday Inn Express. There's some statements that Joshua makes during that interview that suggest, well, maybe there was somebody else or my buddy. But that concern, in my view, would have been the primary concern of the law enforcement personnel that were located at the scene of the accident.
So it doesn't have to be Trooper Vuma's concern as well, because he has to have probable cause to believe that he's committed the offense of driving while under the influence. And so at some point you have to resolve, at least in a probable cause sense, whether in fact there's probable cause to believe that he's driven, because otherwise, waving your hands and having a head cut, and you may signal that this person was involved in the crash. You can deduce that pretty clearly, but that may not be probable cause of criminal offense, which you have to have, of course, to apply for the warrant.
Sure. I would, I guess, argue by contrast then. I think if that is the factor that held the trooper up for asking for the warrant, because he didn't know if Joshua was actually the driver, he certainly didn't know that when he asked for the warrantless blood draw.
We are on the internet, so hang close to the mic, will you please?
Excuse me.
Were any of the three officers that arrived on the scene, that arrived at the hotel, also at the scene before they got to the
Not to my
hotel?
knowledge, and not according to the record that I read.
So part of all of this preparation of a probable cause affidavit would require some considerable communication back and forth with the on-scene officers, wouldn't it?
Well, I mean, it sounded to me by just the testimony that was presented at trial, you heard from, I think, or we had 8 or 9 officers, if I'm not mistaken, who stemmed from DCI to highway patrolmen, and other individuals that were directly responsible for, maintaining evidence at scene, tracking down witnesses, dealing with the injured party and the 2 fatalities that were dead on arrival at the point that law enforcement got there. So I agree with you that there might have been some communication back and forth, but I think if you listen to the dash cam, you don't hear the officer saying, we don't know this, or we need to know that, or somebody needs to contact someone who's looking at the evidence at the scene of the accident so we know if we have enough here to go forward. And
What if within the period of that time, that hour, there's the 218 dispatch and there's some time that en route, and then there's a 317 blood draw, so pretty tight time frame. What if within that time period, as it appears is the case, the reference to another person or the possibility of another driver didn't pan out, as it seems to be was the case? The officers who had dispersed and were at the scene trying to look for another driver or another person didn't find anybody. And so with the passage of time, does it become more likely, again in a probable cause sense, that your client is probably the driver?
I agree with that position, Your Honor, and I would further submit that if we're looking at it from the trooper's perspective and also considering the totality of the circumstances, there was, in my view, nothing presented in testimony at the suppression hearing that indicated that the trooper was waiting to try to figure out the identity and make sure that VORTHERMS was the driver. I think a reasonable, objective reading of his testimony, both at the suppression hearing and at trial, supports a conclusion that wasn't really an issue. Could it be an issue in some case? Certainly.
And I understand your argument in that respect. And if that's the case, and if that's your argument, that's how I kind of understood it as well. Then my other thought is that I kind of gleaned from your argument is that, hey, there's a spot at which, well, he could have sought the warrant earlier. Even if, for purposes of our discussion, we could grant you that point. Mm-hmm. Is that even the test? Because the touchstone of all Fourth Amendment inquiries is reasonableness. And so maybe the test isn't even could he, under some scenario, as we reconstruct this time frame, there might have been a spot at which the trooper could have sought the warrant earlier. Isn't the test, would it have been reasonable for him under the circumstances to have done it? Not just that he could have, as we look back on it, but the difference is, one, moving with all possible dispatch and expediency versus proceeding reasonably.
And if I may, and I'm not trying to not answer your question, but the way I would say it is, my analysis in this is when should he have? And I think, when we're dealing with a warrantless search or seizure, we have a situation where the burden is squarely on the state and the state actors involved in the case. And so in this instance, you have a trooper who justifies his not getting a warrant at any point during the proceedings as dissipation and imminent medical treatment. And so what I am trying to do, and hoping that I can have you see, is that there was numerous instances within this process where not only he could have gotten a warrant or applied for a warrant, but he should have applied for a warrant.
Because it was reasonable, or he should have because it was more expedient in terms of the time frame? Well, because we have to couch it in reasonableness if we're examining this under the strictures of the Fourth Amendment. Would you agree with that?
Well, reasonably objective, I think, is, how we're going to evaluate the determination of exigent circumstances. But I think that...
Well, that just gets you beyond the warrant requirement. Mm-hmm. So, we still have to have overall reasonableness in terms of that, his conduct.
In my view, when I look at this situation, we have, having done a fair number of DWI cases in my life, I would see no issue in an application for a search warrant for a blood draw in this case. Let's just say it was a straightforward DWI.
Most of the discussion has been about DWIs here, but really the reason we're here today is because of the vehicular homicide conviction, which is a serious felony.
Certainly, but...
Does the state have an enhanced need or right to access that blood, given this is not a DWI, it's vehicular homicide, or are they to be treated the same?
Well, I think it is part of the totality of the circumstances that the court takes a look at, and depending on the circumstances presented by the case. But, I think it's important to remember that McNeely didn't do a carve-out based on that issue. McNeely doesn't say, well, if there's an accident or a serious accident or a or a fatality, that decreases the other analysis that we would do if there weren't those issues present. It's part of the overall picture that I think we're told to look at.
So, Ms. Carper, let me have you focus on this court's decision in State versus Fisher. State's position, I think, is it was all reasonable what the officer did for the first 30 minutes and acted reasonably. And then we had accident circumstances at a little after 3 because he gets to the hospital and Mr. VORTHERMS is going into surgery. So at that point, it became exigent. Under State versus Fisher, how is that assessment on the state's part wrong?
Thank you, Justice. I think there's a number of distinctions in the Fisher case as compared to the facts that are presented to you here. First and foremost, the Fisher case, the facts that led to that case took place in Piggstown. It was a situation, and I'll just briefly talk about those facts, situation where an individual plowed into a group of people standing in a parking lot at a very high rate of speed. 2 people were instantly killed. There were 2 vehicles, a boat involved. There were numerous witnesses present that observed the entire accident. There was, I think, I don't want to misstate, but I believe a huge or a very large debris field that needed to be maintained. And in that instance, we had the sheriff testifying that every single officer that he had at his disposal needed to be on scene in order to process witnesses, ensure the sanctity of the evidence, make sure that the scene was maintained. And we also had the situation where the weather was extremely changeable at that point. It was going to start to rain quite heavily. We also, in that case, had a situation where the officer, or the sheriff testified that in order for him to get a warrant, first of all, the process, I think he, in that case, testified it could take 60 to 90 minutes to get a warrant, that he would drive 15 miles to go back to Lake Andes to be able to do that paperwork, and then once got the warrant would have to drive to the hospital where the defendant was being treated, and they knew that the defendant was going to be airlifted to Sioux Falls.
Well, but I'm asking you to focus on specifically the event that caused the exigency in Fisher was this guy's going to be transported in a helicopter to Sioux Falls to be treated medically, and we've got to get the blood draw or we're going to lose that evidence. How is that different from this situation where the trooper arrives at the hospital and the event is he finds out there's going to be a surgical procedure? Is there any difference in those 2 situations?
I think there are, and respectfully, Judge, I think those other considerations played into it. If the situation of VORTHERMS was that they didn't have anyone else that could have done all of those very important functions to maintain the accident scene, interview witnesses, do all those things that could have been done, and you only have one officer that can go through that entire process of applying for a warrant that takes, according to that testimony, 60 to 90 minutes, that's a different analysis. In my view, I think, and I think McNeely kind of speaks to that. And McNeely says, we're deciding to find a per se exemption to the warrant requirement. And obviously the state was seeking it in that case. And the court in McNeely said that, a perfect opportunity for an officer to obtain a warrant would be while following the defendant who would be receiving medical care, because during that period of time, the officer wouldn't be necessarily having to interact with that individual or do anything with that individual. And to me, that's exactly the facts that are presented by this case, where we don't have all of those other issues like we had in the Fisher case. So,
is part of your argument, in terms of the reasonableness, again, the idea that the trooper didn't even try to do that, didn't get underway? So let's say that he had tried and he had just been unsuccessful in terms of getting it served and executed, and they're taking your client into surgery. Does that changes your argument maybe a little bit?
I think so, and that's significant.
2 minutes.
Thank you. That's significant. I would also point out that it's interesting in this particular case that after the 317 blood draw is done, for some reason that isn't really developed in the record, we have the officer taking the blood sample, going out to his patrol car, staying in the patrol car for a period of time, and then applying for a warrant draw.
So let me ask you, before your time runs out, I want to ask you about, if we found there's not exigent circumstances in this case for the warrantless blood draw, we've got a second blood draw, shows 0.093 that was introduced into evidence. Is that harmless error based on the admission of that? And tell me if not.
I would submit adamantly no. It's a much different proposition from a defense perspective to be able to argue extrapolation and other factors with a 0.9403 than it is to try to argue those very same issues with a 0.167.
Was there evidence of extrapolation as to that second test?
Well, I think because of the fact that the first blood test came in, there was some extrapolation testimony, mostly elicited by the state, but I think the defense was kind of hamstrung in its ability to fully develop that because you lose credibility in front of a jury if you're trying to get rid of a blood test result that high. Whereas if you're that close to the legal limit and we have a time spread, like we do in every DWI case where a blood draw is taken, it's an easier argument for the state. And again, that DWI is a predicate element and an essential element of what the state has to prove ultimately for the battery charge and for the homicide charge, as well as negligence in addition to the operation of a motor vehicle while under the influence.
And he was sentenced on the 08 charge.
Excuse me?
He was sentenced on the 08 charge, on the .08 charge,
The judge did
Sentence him on that.
not on the impaired charge.
Right, that's correct. Thank you.
Thank you, Ms. Carper. Ms. Hoffman, you have 20 minutes.
May it please the court, counsel. The state respectfully requests here that the court affirm appellant's convictions because, first, his Fourth Amendment rights were not violated, and he also did not receive ineffective assistance of counsel at trial. But turning to VORTHERMS' first argument, based on the totality of the circumstances, the state here submits that exigent circumstances were indeed present to support this warrantless blood draw. So I'm going to return back to what Trooper Patrick Booman testified to at the suppression hearing and the facts that support exigent circumstances. So he was indeed dispatched at 2:18 a.m. on Saturday, July 1st, 2017, to the crash near Brandon on Interstate 90. And before arriving, he knew that it had been a rollover crash, and a white male wearing black shorts and no shoes was trying to flag down traffic, and this man had made his way to the Holiday Inn in Brandon, about a quarter mile from the crash site. Trooper Booman arrives at the Holiday Inn at 2:31. And as he arrived, Trooper Booman is first aware of multiple fatalities at the scene and someone possibly missing from the crash site. He then makes contact with VORTHERMS, who is indeed, as alluded to earlier, he was bloody, holding a cloth to an injury on his head, and was shirtless and missing a shoe. And he was able to state his name to Trooper Booman, but Trooper Booman testified about how he had difficulty with the spelling of VORTHERMS' last name and had to request dispatch to contact Minnesota to conclusively identify VORTHERMS. Trooper Booman could smell alcohol on VORTHERMS, and VORTHERMS did admit that he had been drinking that night. But he also stated he had not been driving, had been driving with a buddy, and had been sitting in a passenger seat in his vehicle. But VORTHERMS was also having trouble answering questions about this buddy or about which passenger seat he had been sitting in, because throughout this encounter, he's having trouble staying conscious. And he actually starts to lose consciousness while sitting in front of Trooper Booman's patrol vehicle. So an ambulance arrives to transport him to the hospital. And in the back of the ambulance, there's still this investigation is ongoing because there's an effort to obtain the PBT from him. And a successful one was ultimately obtained that indicated a reading of 0.097 blood alcohol content. And Trooper Booman testified that it's about this point that he believes that VORTHERMS has been involved in the crash. And the ambulance leaves the scene at 2:52, only 21 minutes after Trooper Booman first made contact with VORTHERMS. And Trooper Booman further testified that there was this concern about figuring out if another person had indeed been involved in the crash. And this is why another officer did not begin a warrant process sooner. And so these other officers who are at the Holiday Inn go back to the crash site to assist with the investigation. Meanwhile, Trooper Booman follows the ambulance, and the ambulance arrives at Avera McKinnon at 3:06 a.m., 14 minutes later. Trooper Booman intended on continuing his investigation, but on going into the emergency room, he learned that VORTHERMS had lost a lot of blood and would be going into surgery. And it's at this point that his investigation becomes an exigency.
At what point along the way, Ms. Hoffman, does the trooper develop sufficient probable cause? This is the question that I asked to Ms. Carper, and she flipped around. She said, well, I mean, we win if he doesn't have probable cause that he was driving. I mean, so if that's a justification for not commencing the warrant process earlier, that is lack of probable cause that he was the driver and therefore potentially or probably guilty in that sense. At what point along the way, in your view, does the trooper develop enough probable cause to think, yeah, this is the driver, I have now probable cause? If he didn't have it at the outset, maybe you don't even concede that, I don't know. But it sounds like you do.
Well, I should say at first there's no record of what the probable cause was. The affidavit isn't in the record. But I believe at the point that, and Trooper Booman testifies to this himself, that it's about at the point that the ambulance is leaving the scene. And because he knows that VORTHERMS smells of alcohol, and he has this injury, and he admitted he'd been drinking, and then the PVT is conducted right before the ambulance leaves the scene.
Is it the passage of time then that sort of leads the officer to conclude that he was driving? Because that's the other component that has to be present in order to have probable cause to seize the blood.
I'm sorry, could you repeat your question?
I mean, you have to have probable cause that he's the driver. And when do you think that occurs?
I believe he developed enough probable cause by the time they left the scene at the Holiday Inn, but then he was confronted with the exigency at Avera. So he knew at Avera that of various protocols that would create problems with having enough time to get the warrants.
Let me ask you about that, Ms. Hoffman. The Fisher case, similar factually, and from the standpoint of about the same time frame, car accident in Fisher, same here, and about 30 minutes or so before the defendant in each case is transported to the hospital. So you get to the hospital, and then in Fisher, they have the defendant's being airlifted out of Charles Mix County. He's not going to be there anymore. We have a little different situation here. We've got somebody going into surgery, and Booman says, I might lose that evidence. Do I need something more besides Trooper Booman's testimony to prove that exigency?
I don't believe so, because he is the one that knows about the protocols at Avera and the possible problems that could cause a delay. And he's also the one that knows about, even with this telephonic warrant process, about the delays that could result.
Right, but does he have enough background and foundation to be able to say, hey, this evidence or this blood might be dissipated once he goes into surgery because it could be transfusions or medications or whatever. Does he have the basis to be able to surmise that in that situation?
I believe so. He testified to his familiarity with getting warrantless blood draws in those sorts of situations, and the facts that he alluded to about the problems that he believed he was going to face were the same problems that are alluded to in Fisher, about the unknown length of time of surgery, the possibility of getting medications that could taint a blood sample, the possibility of a transfusion. Those are all concerns that were cited in the Fisher case, and they're the same concerns that are cited by Trooper Booman here.
Given the fact here that we have a vehicular homicide conviction, does the state have enhanced right to this evidence without a search warrant versus an ordinary Class 1 misdemeanor DWI?
Perhaps to a certain extent. The McNeely court did allude to some types of DUI cases being cases that have special facts, I believe is the phrase they use. So some cases are more serious than others, but here the key fact is the exigency that's presented at the hospital. So each case does have to have determined on its own unique sets of facts here. And certainly paired with the facts presented at the hospital and the need to preserve evidence here of a serious felony are important circumstances to take into consideration here. This is by no means a routine DUI case. This is a special circumstance that created an exigency.
Counsel, much of Ms. Carper's brief and argument is centered around the information contained on the dash cam video. What is the evidentiary status of the dash cam video? Was it introduced into evidence at the pretrial hearing? In essence, if it was not, is that something this court can then review on appeal?
Well, it wasn't introduced at the pre-trial hearing. It was introduced at trial. And at this point, the state submits that there certainly seems to be a contradiction between the authority cited in the state's brief and the authority cited in the appellant's brief. So perhaps that's a contradiction that this court would like to resolve, but either way, exigent circumstances are found either through just purely the testimony of Trooper Booman and through the dash cam footage introduced at trial. So going back to when Trooper Booman's investigation became an exigency, specifically he knew certain protocols followed at Avera about they are not going to wait for an officer to get a warrant because their goal is the preservation of life. They are not going to do a blood draw during surgery. There's no prediction about how long surgery will take, if there's a transfusion, if medications will be given, and it might even take 15 minutes to an hour to wait for a phlebotomist to conduct a blood draw. And pair this with Trooper Booman's experience and training with obtaining telephonic warrants. And he had done that, he testified about doing that 30 times for blood draws. Multiple judges might need to be called, especially late at night or on a weekend, which was the case here. It was about 3 a.m. on a Saturday. And he knew at one time he had to call 9 judges to obtain a telephonic warrant. So these are the reasons why the warrantless blood draw was conducted at 3:17 a.m. So I think the timeline here is essential to demonstrate the exigent circumstances. Even if we go all the way back to 2:15 a.m., when about the time that the off-duty detective calls 911 about the accident. So we start at 2:15 a.m., 3 minutes pass, and at 2:18, Trooper Booman is dispatched. At 2:31, he makes contact with VORTHERMS, during which time VORTHERMS loses consciousness during this encounter. In fact, in the dash cam evidence, VORTHERMS loses consciousness at 2:40, which is a mere 9 minutes after Trooper Booman first makes contact. At 2:52, the ambulance leaves, and 14 minutes pass on the drive to Avera, and at 3:06, the ambulance arrives at Avera, and Trooper Booman learns of surgery, and is at this point that the exigency begins. 11 minutes pass, and at 3:17, the blood draw is conducted, a mere 45 minutes after Trooper Booman's first contact. So VORTHERMS argues that the process for obtaining a warrant should have begun at some earlier point, but that overlooks the circumstances of what the officers knew at the time and what they were contending with at the scene of the Holiday Inn. The accident had only been called in as of 2:15. As I said, it's still within the first hour of their response. There are known fatalities, known severe injuries. VORTHERMS smelled of alcohol and indicated he had been drinking, but another person was unaccounted for, and another person might be involved in the crash. And this is also demonstrated in the testimony and the dash cam evidence of the officers trying to figure out, is there another person? You need to get serious. You need to answer these questions. But VORTHERMS was losing consciousness and having difficulty responding to these questions, which complicated an appropriate response to the emergency and an appropriate plan. Additionally, the officers, besides contending with figuring out if another person is involved and dealing with VORTHERMS' physical condition, They are also, throughout this time, developing the facts related to VORTHERMS' involvement until right before the ambulance leaves the scene, which is when the successful PBT was obtained. And because of VORTHERMS' suggestion that another person was involved, it was reasonable for these other officers to go back to the crash site and assist with that scene. And at the Holiday Inn, it's also important to note, nobody knows what's going to happen when they get to the hospital. We have to look at these facts in hindsight. Nobody knew what Trooper Booman was going to face when he got to the hospital and what facts would present themselves then. So it is at this point that Trooper Booman is the sole officer presented with the sudden emergency when he became aware that VORTHERMS would be going into surgery, and he had to make that judgment call to preserve evidence of a serious felony. So based on what the officers knew at the time, going back to Justice Salter's questions about what is reasonable, it was objectively reasonable for Trooper Booman and the other officers to continue investigation for the 21 minutes, which, placed in context, that's 1 minute longer than I have allotted before you today to argue. 1 minute longer between Trooper Booman's first contact with VORTHERMS until he was taken away by ambulance to Avera McKinnon to both develop an understanding of his involvement and contend with his injuries. So based on the totality of the circumstances here, it was objectively reasonable to believe that exigent circumstances were present.
Ms. Hoffman, excuse me, I want to ask you about there were two blood alcohol test levels that were submitted into evidence. The first one, which was the warrantless draw, and then there was one after that, which was the warranted draw. And let's assume that first one gets kicked out. So if we don't find exigent circumstances here, that second BAC, 0.093, it doesn't look to me like the state presented extrapolation evidence as to that second BAC if the first one gets kicked out. Would you agree with that?
Correct.
Okay.
I believe the testimony that was presented on that was based on the number of hours and the possibility of what he would have had to drink if his BAC would have been below 0.08 at the time he was driving. That was the testimony that was presented.
You agree, as McNeely suggests, continuing with some of my earlier questions, you agree, though, that as a predicate to undertaking an analysis of the exigent circumstances that the trooper has to have probable cause.
Correct.
That Mr. VORTHERMS committed the offense of DUI. And as well as others, but certainly DUI because that's kind of what we're talking about as a predicate offense.
Absolutely.
Is that impacted by the totality of the circumstances, or is that just probable cause, like we would analyze probable cause in any other case, realizing that the standard is imprecise? Well,
I believe under Schmerber, when it comes to evaluating these types of blood draws, Schmerber gives the 3-point analysis of whether it was reasonably done, whether there was probable cause, and whether there were exigent circumstances. So I believe it would be a separate concern, and it's never been a contention as to whether or not there was probable cause. Even at the time of the suppression hearing, it was pretty much agreed upon by the parties that probable cause was present. As to the second issue, I would merely submit that the record here is not developed enough to review this sort of claim at this time. These sorts of claims are much better addressed at habeas corpus proceedings, which allow trial counsel to explain their understanding of the law and their actions or strategies. And on those principles alone, this court should decline to address VORTHERMS' argument as to ineffective assistance of counsel at this time. As to the experts, Trooper Duran Garcia and Trooper Woschi, the record demonstrates both their knowledge and expertise on the matters that they testified to. And also, the record demonstrates VORTHERMS trial counsel engaged in thorough cross-examination of both the experts and introduced a competing expert opinion in the testimony of Brian Moore. And on that sense, there is no patent usurpation of constitutional rights. And as to the possible testimony of Megan Dower, the record demonstrates that there was probably some intention to call her, but there's no record as to why she ultimately did not testify, and if she could have changed the outcome of trial. And that is also an issue that should only be developed at a habeas corpus proceeding. And with that, the state requests that VORTHERMS convictions be affirmed.
Okay, thank you, Ms. Hoffman.
Thank you.
Ms. Carper, you have 10 minutes for rebuttal.
I'd like to begin by touching again on the issue that was addressed by counsel in her presentation to the court and some of the questions that you presented to her with respect to the probable cause issue. I think if one of the concerns that we're talking about is, did Trooper Broman even have probable cause to ask for a warrant when he's on location at the Holiday Inn Express? I think we have to answer that by looking at what his actions were subsequent to that. Because there was no testimony from Trooper Bowman that said, I wasn't sure at the location at the Holiday Inn that it was him. I didn't think I had enough, so I wanted to wait and get additional information. You don't hear testimony that Trooper Bowman says, while I was following the ambulance to the hospital during that 14-minute, well, the ambulance takes 14 minutes. I think it's a fair interpretation of the testimony presented to suggest that they were already working on Joshua by the time the trooper got there. But let's just give him the same time frame as the ambulance, 14 minutes. From that drive from Brandon to Sioux Falls, he didn't get any additional information that sort of bumped up that probable cause analysis if the theory is there wasn't enough. The only thing that changed, really, is that he gets there, sees that he's being worked on, and Trooper overhears doctors and nurses saying he's lost a lot of blood, he's probably going to go into surgery, all right? So I think it's objectively reasonable for any officer who's involved in a case like this that knows that the defendant is being transported by ambulance for medical care, that it's a very reasonable possibility that that person is in fact going to get medical care. And so if what we're saying is, well, he was just, in that moment and he had a limited amount of time to make that decision, he found out he was going to get medical care and we needed to preserve that evidence. Well, if that's in fact the case, wouldn't that bolster the position that the application for the warrant should have perhaps started at the point that Joshua is in the ambulance and the trooper is following the ambulance to the hospital?
Ms. Carper, can you address the warrant process itself that you think could have been obtained in enough time? You didn't really touch on the trooper's testimony with regard to that.
Right. So there was testimony at the motions hearing that discussed that Minnehaha County uses a telephonic process. There's pre-printed forms essentially where the officer is sworn in, relays the relevant information to the magistrate or the judge, and then that judge makes a determination if a warrant is in fact going to issue. There was some statements made by the trooper at the suppression hearing talking about he doesn't know how long it can take. One time he had to call 9 judges. The reality is we do know how long it probably would have taken in this case, though, because when he approximately started the warrant process at 3:45, he had one at 4:02.
But that's looking in hindsight as to what actually happened. Don't we have to look at what his thought process was at the time that you think he should have started obtaining the warrant? What did he know then?
Well, what he knew then, I think, is just serious car accident. He knows, I think, that there's fatalities at the point that he's following.
I mean about how long it takes to get a warrant.
Oh.
What did he know at that time?
Well, I mean, what he testified he knew at the hearing was that, on one occasion he had to call 9 different judges, and that it can take some time. There wasn't any specific statements that he made that it would take a half an hour to get a warrant or 60 minutes to type up the paperwork for the warrant, as was present in the Fisher case when we talked about the circumstances presented there to justify exigent circumstances. There was nothing testified to that effect by the trooper in this case other than to say, I don't know how long it's going to take. But he knows that when he gets in his car before he drives to the hospital. I mean, his experience and training and asking for warrants, he's asked for a number of DWI warrants over the phone in the middle of the night and on weekends and received them. So I think while it is certainly true that there could be instances where it might take a longer period of time to get a judge, wouldn't that justify the position that you started sooner, though, rather than later? I mean, if in this case we had some remarkable piece of evidence that came up on the drive at the hospital that somehow tilted things in a different way, one perhaps could accept that argument, I think, more. But in this case, there's no new information that the trooper gets from the moment that he starts following that ambulance till the moment that he does or asks for the unwarranted draw, except he says that he's told that VORTHERMS is going to get medical treatment. Well, that's something that he, I assume, considered at the point that he's following the ambulance to the hospital. And if he doesn't, then that's perhaps a concern in terms of how he is looking at the circumstances as they present themselves overall. And I also think, why even do the second warrant application? If you have your blood draw, your first blood draw, the reason why he gets the warrantless draw is because of the dissipation of evidence and the looming medical treatment, which might involve blood transfusions or medications that could throw out the result. So what then would be the possible motivation for him to seek a warrant? It's later at night now, which is one of the issues that he identified as possibly causing it to take a longer period of time to get a warrant. The treatment that he was concerned about impacting the blood test has already been given. So it kind of, the position that he takes to explain why he can't get a warrant for the earlier draw apparently no longer exists when he gets the later draw. So that to me is a mutually inconsistent position that he's taking with respect to justifying his actions on that night.
I don't know if they used it that way here. I mean, there may be a question of that, but it's possible, I suppose, if they got a warrant later, perhaps depending on how that came out. And of course, he's making the decision before he knows the results. But depending upon how that came out, I suppose it's possible they could seek to extrapolate from additional blood evidence.
It just struck me, and perhaps it was because I wasn't trial counsel, but to me, looking at it from the issues raised on appeal, it was like, well, you told us you wouldn't have time to get a warrant before, when it took almost the exact amount of time to get from the location at the Holiday Inn to the hospital to the blood draw as it did for you as the custodian of that evidence to take it, seal it, walk out to your patrol car, be in your patrol car for a little while doing we don't know what, and then saying, no, at about 3:45, then I started to apply for a warrant.
But the state of the record is, as I understand it, that, I mean, in this case, as it turns out, it took him about that amount of time, and it wasn't all that remarkable. But it seems like it's unrebutted in the record that from the trooper's testimony that it could take a lot longer, and you really don't know until it's all over.
But, I mean, coulds and woulds and maybes, I think, are not necessarily the type of speculation that is expected of you when you're reviewing whether or not the trooper's actions were objectively reasonable under the circumstances.
Counsel, would you also, I'm sorry to interrupt
you,
would you also address the evidentiary status of your dash cam footage? It wasn't introduced in front of the circuit court judge as part of the evidence presented at the suppression hearing. It came in at trial. Is it properly considered on appeal?
I believe that it is.
If so, what case do you rely on?
We cited the court to the Heck case, which cites to United States versus Hicks. I believe in both of those cases were situations where there was an issue raised on appeal that came from the whole of the record, where the appellate court had an opportunity to take a look at information and evidence that wasn't necessarily relayed to the trial court.
2 minutes, counsel.
Thank you. The additional cases, there's the 2 Eighth Circuit cases, United States v. Brown, and United States v. Anderson, and all of those cases stand for the proposition that on appeal in consideration of a constitutional right violation, this court looks from the totality of the record and could take into consideration information that wasn't presented to the court at suppression. I would also submit that unlike some of the cases cited by the state, this is one that was properly and fully raised by Joshua in his appeal, and so I think the court has the ability to look at all of that information to make a determination as to whether the trial court's conclusions and findings were warranted.
If that winds up being our rule, in this case, it may apply, we would expect, beyond this case, and that may, in other cases, not work to the advantage of a defendant.
Are you suggesting I might be responsible for making bad law, Your Honor?
Pardon me?
Are you suggesting I might be responsible for making bad law?
No, not in any way. No, by all means not. I'm just saying that there's that possibility.
I understand. And with the little bit of the time that I have remaining, Your Honor, we understand the standards that are presented on raising ineffective assistance of counsel on direct appeal. However, it's our position in this case there was no legitimate trial strategy to justify not filing a pretrial motion to test the trooper's testimony with respect to the data and the analysis of the data in the black box, as it were, from the vehicle that Mr. VORTHERMS was driving. As you know, in this case, not only do we have to prove DWI, we also have to prove negligence. And speed was definitely a significant factor as far as the state's arguments and presentation to show that not only was Mr. VORTHERMS operating a vehicle while intoxicated, he was doing so in a reckless manner, driving 96 miles an hour. In my view, I can think of no legitimate reason why you would not do a Dober test on that person's knowledge and ability to meaningfully testify about the data from that box, particularly in this case where airbags didn't even deploy. So I understand that normally we would have a fully developed habeas record to examine this, but in this particular case, under these particular facts, given the significant impact of that testimony, to our opinion, there would be no legitimate reason not to test that in a pretrial hearing.
Your time has expired.
Thank you very much.
Thank you, Ms. Carper. Court will be in recess for 10 minutes.